is you came back here on August 27th and you asked me to adjourn it to September 24 so he could pay.
Ma'am, I'm not too smart and I don't know. I've never done this before.
This case right here is the perfect example of how messy landlord-tenant disputes can get when emotions, confusion, and poor paperwork collide. We've got David Wallow, a 76-year-old landlord just trying to stay afloat, and Michael Methoff, his tenant who insists he's been paying what he can. The tension? Off the charts. The confusion? Even higher. What starts as a rent dispute quickly turns into a battle over who's telling the truth, who's scared of whom, and who even knows the law. But here's the twist. The judge catches something that flips this whole eviction case upside down. Stick around, because by the end of this one, you'll see how one small mistake can undo an entire case in seconds.
The case of David Wallow versus Michael Metcalf. Case number 25C-2952.
Michael Metcalf.
Can you state your name, please, sir?
Me,
Yes, Mr.
David W. Wallow.
In this matter, we're here for a termination hearing today. Have the two of you talked? Have you worked anything out, or are we moving forward with the hearing?
No, I hardly ever see him. Sneaks in at night and leaves when I am around.
So are you requesting a
I've
hearing?
given you enough chances and everything.
Are you requesting to move forward with a hearing today, Mr. Wallow?
Yes, I am.
Mr. Metcalf, are you asking for a hearing today, sir? What do you want to do?
If we can't reach some type of resolution, then, please, we can move forward with the hearing. There are no other options, are there?
Nope, those are pretty much the options. You've had the opportunity to seek counsel. You told me that you were going to be hiring Blanchard and Walker, but I don't see them here.
I said that I had a consultation with them. And I mean, financially, Your Honor, I just wasn't able to pull that together.
All right. So
This moment right here, classic courtroom chaos. Michael claims there is a lease, but can't produce it. Then David insists the lease is attached to a letter he mailed. The judge is sitting there trying to piece together whether this is a real contract or a printout from someone's inbox. Folks, this is why paper trails matter. Without proof of a valid lease, the court can't verify terms, amounts, or even the tenancy itself. It's like trying to evict a ghost. What would you do if your landlord said it's in the email, but couldn't show the actual document?
in this particular case, he's basically saying that you're on a month-to-month lease and that you haven't moved, although he told you you need to move. So what is your defense?
Well, I know that he put the notice in for court, and I have been making genuine efforts to try and pull together reliable employment to compensate him. And, you know, as money has come in, it's just been really tough, Your Honor. I worked for the reopening at Hobbs Restaurant for 2 months.
I'm not. Your ability to pay or lack of payment is not what we're discussing. I want to know whether you believe you have a right to still be there. Do you have a lease that I'm not aware of?
Oh, there is a lease. I mean, there is a lease document that we both signed. Yes.
Where's that document at?
You should have that copy of that lease, Judge, Your Honor.
It would be saved in one of my email accounts, Your Honor. I didn't think that I would.
Hold on one second. Mr. Sand.
You should have a copy of that lease along with a letter I wrote saying my health condition, and I stapled it to that, and I sent it last week, and they told me you had the letter, so I don't know. It's his lease is on that letter.
This is a lease that says he's paying $500 a month per month. It's
yes.
A 1 year lease. This is a month-to-month lease.
I know you don't even pay $500 a month.
Okay.
I got bills to pay, Your Honor.
I heard that, sir. All right. I'm going to be back to this in just one moment. Okay. I'm going to pass it. The court will recall the case of David Wallow versus Michael Metcalf. Case number 25C-2952. All right. I'm going to swear you all in again. Thank you. You both may lower your hands. So,
I apologize.
Mr. Wallow, this is your case. So the way it works is you start first. So, Mr. Wallow.
Here's where it gets emotional. David, the landlord, explains he rents out rooms just to keep up with bills, something so many seniors can relate to. But the judge can already sense frustration building. He's not just talking about unpaid rent, he's talking about survival. Yet legally, wanting someone out isn't enough. You need proper notice, procedure, and documentation. This scene is a perfect lesson in how personal hardship doesn't override due process. The court's not cold, it's just bound by law. Still, it's hard not to feel for this man who's just trying to keep the lights on.
Yes, ma'am.
You filed this action here before the court, asking that the court evict Mr. Metcalf from your home.
Yeah, he supposedly wanted to rent a room from me because his mother lives here too. I got 2 rooms. I sort of rent out to roommates because I don't have enough money to pay my bills. And when these people don't pay, I'm getting behind on my bills.
Mr. Wallow. So first of all,
Yes.
so both of you, here are the rules. If it's a
Yes,
yes,
ma'am.
if it's a yes or no question, please answer with the yes or no. Okay? If it
Yes.
requires more explanation, then you can give more explanation. If I ask for that, okay? If you don't understand the question, ask me to rephrase it. If you didn't hear the question, ask for me to repeat it. You filed an action to terminate the tenancy. Is that correct?
Yes.
You indicated that he's in possession of the basement room?
Yeah, I have a nice room in the basement with carpet, his own bathroom and everything. Finished basement, finished room.
Does it have an egress?
Yes, it does, ma'am. It does have an egress.
What's the egress?
That's the escape window if there's a fire. You gotta have a window to escape out of. It has to open up 5 feet, which it does. Because that a regular company put it in.
All right.
Because in the basement, all you got those little windows, and you gotta have one window where the person can escape when there's a fire.
Okay, sir, I said okay.
And so I put that in.
So you can stop repeating that, okay? Request to terminate his tenancy, you indicated it's for non-payment of rent.
Right.
How much rent are you claiming he owes you?
Well, he had some company pay his rent for a year.
Sir,
Yes.
the question is simple. How much rent are you claiming that he still owes you? And I just want a number.
Boom, the emotions explode. David admits he's owed 2 months' rent but quickly shifts, "I just want him out." That right there is the legal pivot point. When a landlord changes the reason from non-payment to just get out, the entire legal foundation collapses. And when he throws in, "My girlfriend's scared of him," it adds drama but not legality. The judge's job? Separate the fear from the facts. You can feel the tension. One man desperate for peace, another desperate for shelter. But sympathy doesn't win eviction cases. Paperwork does.
Oh, just 1,000, 2 months. But I want him out of my house. Because my girlfriend, she's scared of him and she had to move. She couldn't take it no more.
Hold on one second, please. Thank you. All right. I'm sorry. I had to talk to someone about how quickly we got to be out of this space for someone else to use it. All right. So, sir, now you're saying you want him out, so you filed a termination of tenancy, and initially you were saying you wanted him out because of rent, and now you're saying you just want to terminate the tenancy?
Yes, I don't care about the rent right now. I just want him out of my house. Because I'm not in too good a shape. And he scares me to death sometimes.
And you indicated that there is a lease.
Yeah, he wrote it up. I always have the people write up their own leases when they move in here for a roommate, and that way there's no questions asked.
And
It's in his handwriting. You should have the papers. You should have the papers of that section in there.
And in this lease is basically 2 paragraphs. I, Michael Thorne Metcalf, hereby agree that I'm renting a 1-bedroom and bath, including TV and furnishings at the address. The monthly rent is $500.
Yeah.
Utilities, rent is due the first of the month. Is that correct?
Yes, ma'am.
And so that
That's correct.
is a month-to-month lease?
Yes, that's what he wanted.
Okay, thank you. Mr. Metcalf, what
Yes,
is,
ma'am.
what is your dispute with the facts? So, first of all, sir, do you acknowledge that he served you with the notice to quit?
Uh,
Let me
there's
finish my
inaccuracy
question.
on the date that.
Let me finish my question.
Yes, ma'am.
That he served you with the notice to quit on June 3rd, 2024?
I couldn't give you a specific date that the document would have been received by me, but I will say that I think some of the dates on that document were inaccurate. If you just look at them, and just for the record's sake, I think the year or something on there was not.
Now Michael finally fights back. He says he's been paying what he can, insists he's been respectful, and even corrects the landlord's claims, saying the girlfriend didn't leave out of fear, but because she's in hospice. This is where the courtroom gets real. He's not angry, he's pleading. But here's the legal kicker. Paying partial rent after notice doesn't automatically fix an eviction. Still, it does show good faith, and that's something judges always notice. Do you believe Michael's trying his best, or just buying time?
Right, it says June 3rd, 2024.
Right, and the month, it was like the month and the year, and it was just not the right date that was listed on there. I remember thinking that. So, I made a payment of $300 to him, I think just 2 weeks ago, and while the first avenue of employment that I had didn't pan out for me, I have been working like as a privately hired by a family on the north side of town. By the golf course, just helping them do home reno and landscaping and stuff. So I have been trying to work regularly and was hoping to make another payment to him by the end of this week, or well, by the end of the weekend, really, because I work for them largely on the weekends and in the evenings.
I don't know if you indicated whether or not, oh, you heard whether or not he said he is not trying to get rent from you anymore. He wants you to leave.
I did hear that, but that was, that to me, that's news to me, because our understanding when I gave him the payment was that I was trying to make payments in excess of what I owed for rent to try and start paying back some of what I owed him. We had that discussion, and although there is nothing in writing, but we did talk about it. And I just want to comment and say that, he's him claiming that his girlfriend moved out because she's scared of me. Like she moved out because she's in hospice and went to a convalescent home. So I feel like he's just trying to misrepresent things a little bit to make it seem like that would be a, suitable reason to kind of usher me out of here, which, I take offense to that, because I've always been nice to Dave. I never invade his personal space. His bedroom and stuff, is his, and he's explosive with his like anger, but like I do my best to keep the kitchen clean and communal areas like that, free of debris and whatnot. And it's just, I don't know, that seemed wrong. So I just felt like I needed to say something.
All right, so is there anything else that either one of you would like to say?
Just that Your Honor, if this is going to result in, me being told that I've got to leave, I just hope that I can have a little bit of time, because, knowing whether I'm getting money together for him or knowing whether I'm getting it together to try and find, to make a down payment on a lease or just to get a room somewhere else. Like, if it's like, you got to be out tomorrow, I have no idea what I'm going to do. So I will say that.
This is the turning point, and honestly, it's brilliant. The judge lays down the law. Once you file for eviction, you cannot accept rent. Because the moment you take that payment, you acknowledge the tenancy still exists. That one action voids your own case. David thought he was being reasonable, taking partial payment, but legally, he just destroyed his eviction claim. This is one of those "oh no" moments every landlord dreads. The courtroom goes silent because everyone realizes this whole case just evaporated.
You would get 10 days to move if he were to win. Okay.
Okay. All right.
But this is the other problem. Mr. Wallow, I need for you to listen to me very closely. So
Say that again, ma'am.
I need for you to listen to me very closely.
Okay.
You filed an action to terminate well, let me ask one before I make my ruling. Mr. Metcalf, did you say you paid him some money since this matter was filed?
I did. I gave him $300 out of I worked at a restaurant for 2 weeks. It unfortunately was not a good fit, but I took the money from that paycheck and gave him the majority of that 2 week paycheck. And as I said, I've been trying to, like, I just paid my phone bill and any cash that I have.
Mr. Metcalf,
I'm sorry. Yes, ma'am. Yes.
did you pay him?
I answered your question. I did. Yes. Although I did. Yes.
Mr. Wallow, did you accept $300 from him, sir?
Yes, I did, but it's in my safe because rent's $500. I did tell him that.
So, Mr. Metcalf, here's the thing. You filed an action to terminate his tenancy. Once you file an action to terminate tenancy, you can't accept rent. If you accept rent, it voids the actual termination for tenancy. So you got to decide which one you're doing. Either you
Well, that's why I kept it in my safe.
Stop talking over me.
Okay, I'm sorry.
You need to decide whether you are going to accept money or you just want him out.
I want him out.
Well, you can't do that now because you've already voided this particular case.
You can see the judge trying her best to explain things calmly, but David's frustration and confusion take over. He's 76, struggling with health issues, trying to handle complex legal paperwork on his own. And that's heartbreaking, but the judge can't bend the law out of sympathy. She even warns him, "You'll have to start over." You can feel the exhaustion in his voice, but the judge stands firm. "If you didn't listen, I can't help you." This moment is a raw reminder that courts run on rules, not emotions, no matter how tough the story behind them.
So if you file another case, first of all, it has to be because you don't have a lease. I can't give you legal advice. You have to file it properly. You didn't file it properly for so many reasons. You need to listen so you can try to get it right next time. So listen, okay?
Well, ma'am, I'm 76 and I'm in bad condition. I don't understand.
If you don't listen, he's going to be in your house forever. So you can be 85. You still have to listen.
I don't think I'll live that long, but okay.
Or you cannot listen, and I can just rule that you will.
I am listening to you, my honor.
Okay. So you got to file an action to terminate the tenancy based on the fact that you just want him out. Yes. And you got to file the paperwork properly. Your notice to quit that you served him, first of all, has the wrong year that you served him on, which we can rectify by you saying what year you served him on. We can fix that. But you can't give him a notice to move. If you serve it on June 3rd, 2025, you can't give him a notice to move by June 4th, 2025. You got to write the proper notice on there. He gets 30 days.
Yes.
So you got to do that properly. And then in your complaint, you got to say that you just want him to move because he doesn't have a lease. You can't say that you want to accept rent. You said this was for rent, and then you accepted rent from him. So you void the termination. You now have to start a new case. And in addition to that, what makes it so clear that that's what you did is you came back here on August 27th and you asked me to adjourn it to September 24 so he could pay. And then he paid. So now you can't just file this action this way. You got to start over.
Oh, bother. Ma'am, I'm not too smart and I don't know. I've never done this before and I'm not very smart and I'm doing the best I can with what I got. Girlfriend died 2 years ago, my other girlfriend. Now I got a new one. She won't live here. She moved over there. Her clothes and everything are still here. I have to take her clothes over and shoot.
I'm really sorry about all of that. And I'm really sorry that you are where you are, but I can't not.
I can't help it.
You have to follow the law and you have to listen if you want to get it worked.
In other words, you're trying to say I'm dumb, right?
Oh, God.
Oh,
All right.
no.
I'm done.
Because, ma'am, I did the best I could.
Okay.
I'm not on D's and E's all through school. I've had 2 head-on injuries, and I'm doing the best I can. I got to have rent every month so I can pay my bills. So I got 2 roommates.
I understand.
Okay,
And I'm not saying any of
Thank
that. I'm just telling you what the law requires.
um,
That's it. So if you didn't listen, I can't help you any further, sir.
What a case. One man trying to protect his home, another just trying to keep one. And in the middle, a judge balancing compassion with the letter of the law. The key takeaway? Eviction law is precise. Accepting rent voids termination. Dates matter. Paperwork matters. Emotion doesn't rewrite legal timelines. Still, you can't help but feel for David, a man fighting more than just a tenant, but time, money, and health. If you found this case as eye-opening as we did, hit that like button, drop a comment with your thoughts. Was the judge fair here? And don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.